Welcome viewers. Friday, attorneys for Donald Trump's co-defendants in the election racketeering case and Georgia prosecutors clashed over whether the state has the authority to charge people who voted for Donald Trump as president. Three of the co-respondents are conservative allies of the previous president in 2020. Despite the fact that Democratic President Joe Biden won the state, they were charged with forgery and pretending to be public officials. As we proceed with this video, please take out a minute of your precious time to click the subscribe button and the notification bell for more updates from us. Their attorneys argued that the state cannot prosecute them because presidential electors are governed by the federal constitution and any disputes pertaining to them are resolved by Congress. However, according to Fulton County prosecutors, it would be absurd for Congress to ignore certified presidential electors because states have long supervised how federal elections are conducted at the local level. The dispute has not been resolved by Scott McAfee, the superior judge of Fulton County. He gave defense attorneys until January 2 to respond, and prosecutors had until December 15 to submit additional arguments. The body of evidence against Trump and 18 co-respondents accused them of a scheme to upset the aftereffects of the 2020 political race. Trump and the three people accused of being fake electors, state GOP chairman David Shafer, state senator Sean Still, and Kathy Latham have pleaded not guilty, despite the fact that four co-defendants have admitted guilt. The phony balloters have requested to move their case to government court, yet a bureaucratic adjudicator declined. The 11th U.S. Circuit Court of Appeals is hearing an appeal regarding the request. The phony balloters contended they met December 14, 2020, simultaneously as real official balloters to save Trump's choices in the event that he prevailed upon forthcoming legitimate difficulties casting a ballot debates. Be that as it may, Governor Brian Kemp guaranteed the majority rule record of voters for Congress to depend on January 6, 2021, as a component of confirming Biden as president. Craig Gillen and Holly Ann Pearson, Shafer's attorneys, argued that federal law mandated that any and all disputes regarding electors be resolved by December 8, 2020, or Congress could choose which electors to recognize. A claim was all the while forthcoming by then testing the outcomes. Gillen argued that the case should be dismissed due to the fact that the alternate electors had not broken the law as it existed at the time. Gillen stated, "It ought to stop now. They ought not be compelled to go through a 4-month preliminary and afterward let the court know what they have done is legitimate." Pearson asserted that because federal law had prevailed, the state had no role in selecting electors as long as voting disputes persisted. She stated, "The state cannot criminalize what federal law allows." Be that as it may, delegate-led prosecutor Will Wooten said such rationale would be silly. He said if forthcoming claims would crash the affirmation of state balloters, Congress could figure out who won the administration while overlooking citizens. "That's ridiculous. It has neither rhyme nor reason," Wooten said. The defense